The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
We are on the last bill that we're going to hear today, and that is 2480.
Titanic also sunk today.
Titanic. The Titanic of bills. Is that what you're predicting?
I'm just saying.
Well, that doesn't bode well. Okay, Paige.
Mr. Chairman, members, House Bill 2480 requires the Supreme Court to license attorneys for the practice of law in Arizona, and states attorneys are not obligated to be a member of any organization to become or remain a licensed attorney in Arizona. With that, I'm happy to answer any questions.
Any questions for Paige? Hearing none, thank you very much. Sponsor, our very own John Allen.
Well, I want to thank you for hearing the bill today. For the record, I'm State Representative John Allen, District 15, the North Valley, the jewel in the crown of Maricopa County in the state. And I'm very pleased to talk to you about this important issue today. The State Bar holds a special place in our Constitution and has been on its own without regulatory advice from the legislature since 1983. Prior to that, it was in statute from 1933 through 83, where the legislature was able to contribute to the form and duties of the bar, and it was sunsetted or it went out of legislation. We don't know which one. I can't seem to find it in the in the record, but the board then was the bar was then reestablished by the courts, and now we're here, and there are some problems with the way the Bar Association is run and some of the cultural issues that go on in it. And yet we have this separation of branches. And so I've come up with a bill that I think addresses the cultural problems and yet holds tight to the constitutional formation of this important activity in the state. First of all, if you read the bill carefully, I redelineate the very things that are in the Constitution that the bar is supposed to be doing. The only thing that I change is that you no longer mandatorily have to pay dues. The Bar Association has morphed into a semi-association because they have a board and you have voting rights and other things, and yet also a non-choice, non-right-to-work organization in the state, and where the capturing of dues is mandatory, even if you're not actually plying your trade at that time. Even if you've let your license go dormant, you still have to pay dues. And that's fine for many things, except for the courts do not have the legislative authority to have a levy. And that's what this is. It's up to us to set levies, not the courts. They can charge fees for service, but they now have an annual levy against a certain aspect of the court which they do not have a legal right to. Now, instead of fighting this out in court, I'm just going to correct it legislatively. This does not, and you're going to hear from the Bar Association, they do many great things. I could have gotten quite a few people to come and speak to some of the things they're not too happy with. But many of them are afraid of the bar, and they don't really want to come down. So it is a circumstance where they wield a lot of authority, and they have allowed themselves to morph into a structural scheme that is no longer constitutional. So you probably heard a lot about how my bill is not constitutional. It is, because from 1933 to 1983, the legislature was an equal partner in the making of rules for the bar, and that was never overturned by another court or even challenged. The subsequent picking up of that activity by the bar, most of what they do is constitutional, except for the collecting of dues, which they have taken to a point which they've taken an authority in which they do not have under the Constitution, and my bill corrects it. And I know that this is going to be a difficult vote for many, but this is an endeavor worth doing. They're moving the furniture around in our yard, and I just wanted to take it back, the feng shui of legislation. Thank you very much.
Thank you. The feng shui of legislation. Well, I appreciate the way you explained that. You know, Representative Allen and I haven't really had a discussion, but I appreciate that. I'm an attorney who's in active status, and I do have to pay the fee. I do get the magazine.
And Mr. Chairman, to that point, I am not an attorney. I'm in car sales, so I know I'm going to hell. But, you know, and now I'm a politician, and now I'm playing with lawyers. So really, I have no chance of getting out of this. But I have a sister who's a lawyer who, you know, is in another state. I have a brother-in-law who was a lawyer in this state, passed on a few years ago. I have no dog in this fight. But I do run into a lot of attorneys who feel that the culture of the bar has become toxic to their activities, and they're forced to participate in a manner in which they feel is unfair and not legal.
Okay. Thank you very much. We have any questions for Mr. Allen before we bring up
Here's one.
Mr. Quesada?
Thank you, Mr. Chairman. Mr. Allen, I guess I understand, and I would say I probably believe you that there are some members that feel that way about the bar, but I guess my question is that just a select few members, or is it the large majority of members of the bar?
And
Mr. Allen?
And to that question, how would we know that about anything? And I've tried to be very careful not to add in anecdotes, because that is always a troubling way of legislating. But as a legislator, and being in with my constituents and others, you do see that there's a theme amongst many lawyers that they feel as if the bar is hostile towards them. And they don't represent the lawyers, they represent the people, but they do it with a tax upon the activities of lawyers. And that is and so whether you think this goes on or not is almost secondary to the point of they are doing something that is not within their scope of ability to do in the first place. And that's what my bill does. It carefully redefines them back into their constitutional box.
Thank you, Mr. Chair.
And I think that's the position that's kind of compelling is whether it is a levy, whether it is a tax, and you know, that's an interesting take on it. So
I'm an interesting guy.
you are, Representative Goodell.
Mr. Chairman, Mr. Allen, have you had stakeholder meetings with the members of the bar, with the attorneys that are concerned and trying to vet this process before the bill?
Madam Chair, Representative Goodell.
I prefer to be called Mr. Chair than Madam Chair.
She's my Madam Chair in education. I'm all confused.
Oh, okay.
I'd rather defer to her.
I mean, I have answered to Madam Chair, but it's not my preference.
With that shirt, it's hard to tell.
Please proceed.
Mr. Chairman, Madam Chair, this is one of these situations where I've had conversations with several members of the court and with and only yesterday with the executive directors of the bar and their spokesperson. And these are not evildoers. No. But this is not something I believe that there's going to be any room for compromise, because it's only one step that I want. And I am assuming the only thing I'm asking them to compromise is the only thing they don't want to give away, and the only thing I'm not willing to give away is the only thing I want. So it's not at one of those circumstances where there's a halfway point between them. At least I don't see it, unless you could help me. But I want them to be a open-ended association. And
to that point, Mr. Chairman, but you're collapsing a system.
no,
The Bar Association has a system in place, is how they operate, and has been doing so for
since 1933.
1933. Now we're 2013, so quite a few years it's been operating as a system, a service to the public, to the courts. in one fell swoop, you want to disband the state bar and swoop it over to the Supreme Court, but you've not had any conversations with those members, not in consent, not in compromise, but to say, okay, here's concerns. How do we get there? How do we redesign a system that protects the public? And it's a huge issue.
Mr. Chair, Madam Goodell, no, I appreciate your concern, and I would never do that. They are already in the court. They are a function of the Supreme Court. They operate completely under their guides, and the Supreme Court does other activities that are similar that don't involve the administration of lawyers out of their own budget already. So these are not activities I'm asking to end at all. It's just a matter of if they're doing court activities which we appropriate funds for through legislation and through the budget, we pay for the courts. Mm-hmm. These are other activities that should be paid for through legislation, the appropriations procedure, not through a levy on an activity that's also under their guise. They just don't have the right to do that part of it. Their arguments of their services and stuff like that are irrelevant to mine. I think they do some very good things. I also think, though, that the circumstances in which they've creates a certain cultural conflict that this bill helps alleviate. And 32 other states have the setup in which I'm proposing.
May I clarify to that point? Because I'm not sure. I mean, I either misunderstood you or her question she misunderstood. One of us did. From 33 to 83, you had a non-compulsory bar. Is that right?
I don't know if it was non-compulsory. No, I think it was compulsory, but it was under the guise of legislation, not the courts.
Oh, okay. Okay, then I misunderstood that.
Yeah.
And then, Mr. Allen, so you're not disbanding the bar.
Not at all. No.
Okay, so that part I understood correctly. The other part, so I think you understood half, I understood half, because he's not disbanding the bar, he's making it voluntary. And if you don't become a member of the bar, you're still under the auspices of the court.
And all their rules.
So you don't become an unregulated profession, it just simply is.
Transfer.
So, for example, I'm inactive. I haven't practiced in probably 8 years, and I probably didn't practice very well before that. But I probably shouldn't say that for like malpractice, okay? Has it statutes run yet? Statute of limitations?
Bars out there, be careful.
So, yeah. So for me, if I chose not to be a member, I wouldn't have to pay the fees that I pay every year to get the magazine. And again, I told them yesterday, no disrespect to the magazine. I'm sure it's lovely. I'm just not practicing, and I don't really stay up on it. So I think that's what he's going for is that the compulsion for me to pay essentially to be a member when I don't necessarily want to be a member. This would change that. I would still be as a licensed attorney under the auspices of the court, but I wouldn't have to be a member of the bar. That would be voluntary. If I, as an attorney, thought the bar was providing a service that was valuable, I could join and I would get the benefit of that association. So I think, is that
Correct. That is
okay.
correct.
All right.
And Mr. Chairman, I could give other, if we move this to an example in the executive branch where the MDV licenses us to drive, but now we are all part of some sort of voting system to see where we want to go as drivers. That's sort of the circumstance. I mean, it's not the purview of the executive to create these sort of things, and it's not the purview of the courts to create closed systems. It's up to the legislature to appropriate funds for these activities.
Okay, so let me clarify then on the 33 to 83 was the bar existed, but what you're saying is it's not unconstitutional because that's one of the claims is constitutionality. You're saying
Correct.
You're saying what you're wanting to do is what was done from 33 to 83.
Well, what I'm saying here is that we have the ability to affect this particular activity because we've done it in the past. Okay. Whether we're mirroring what happened in the past, I'm not saying. I'm saying that, but because we've had a legislative interest in this activity in the past, it was never challenged, it was never changed, it wasn't defeated in
right.
court.
And I'm not suggesting the exact policy. I'm talking about the authority that's being exerted.
Yep.
Because the constitutionality issue is going to be one of separation of powers.
Correct.
But for 50 years, the legislature exerted that authority, and it was never challenged.
Yep.
It was never deemed to be unconstitutional.
And that's why I'm very careful in repeating the constitutional language in this bill so that there's no misunderstanding of what I consider their powers and duties.
Okay.
It's just towards the law.
All right, I think I'm clear. Did you have other questions?
No, sir.
Okay. Mr. Orr.
Mr. Chairman, Representative Allen, just as a more of a point of clarification, 33 to 83, when the bar was under the purview of the legislative branch, was membership mandatory or voluntary?
Mr. Chairman, Mr. Orr, I think it was. I'm not sure if it was consistently, but I'm at some point in that time it was. But I think at that point we would have had the ability to change that. It wouldn't have been. I mean, because it was already formulated under the legislature. Now, I know there's some people waiting to talk, and I don't want to completely, ramrod my idea through it.
No, they're going to get a chance to speak,
Okay.
but I think we need to be clear on what you're doing.
Yes.
Because like I said, I haven't had any discussion other than saying, I'll hear the bill. It's interesting. Other states have voluntary bars. I am a member of the bar. And I think they do some good things. I don't think as an individual, they can make a broader argument that is the greater good, but as an individual attorney, I don't think I get anything for my annual fee, which is not insignificant.
And I just want the members to know that I'm not just picking a bone with these guys. I see a structural problem with the way that this is formulated.
But to that point,
Representative Goodell.
Mr. Chairman, you're asking us to, and I think you used the word assume, that there are people out there in the streets who would come in and make testimony against the bar or the problems they have, the concerns they have, but yet they're not here. So we're asked to make a judgment on testimony that's not present.
Well, if I may respond, I can tell you that is true. I can't tell you that it's 60-40, 50-50, 80-20, but yes, there are attorneys out there that, and I know in my circle quite a few, that it's not necessarily that they hate what the bar is doing.
No,
they don't think it's necessary to be a member. It could be done differently. But there are some that I think are concerned, just like anything else. When you have the power to take somebody's license, there's going to be a certain level of trepidation.
Yes.
But again, I can't tell you percentages, but I know that there really are three kinds of people that deal with the bar. There are those that think the bar is absolutely wonderful and it's necessary, and without it, the practice of law would be horrible, and you'd have rogues. Then you have those people that really don't like the bar. They've had a bad experience, or they're afraid of them, or whatever. Then you have guys like me. I don't think I get anything, and I just do not have to, because I agree, and that's the first time I've heard that levying a tax for me simply to have a license. Okay, I kind of agree with that.
Is that correct, though? We don't have any testimony other than Mr. Allen.
Well, me.
Well, you, yes. Well, but you.
For discounting me, Ms.
No.
Representative Goodell.
No.
Madam,
Your
Mr. Chairman.
opinion I value highly.
Well, thank you.
Madam
I'm very concerned that we have the Supreme Court, we have a bar, and we have not taken due diligence to meet with them to say, hey, we have these concerns, to discuss with them what could be done, and we just do a bill to step all over these folks. We can go back to the tax and levying a tax. I'll believe it's true.
So sweet.
I may have a bill someday.
Yeah.
No. And I'm just concerned about, there's been no discussion at a foundational level to say, we really are concerned about the way the bar is organized, and we have some concerns about the tax, and work with their legislative liaisons, work with the courts, and we just, is everybody okay?
Yeah.
That,
Gerald, just getting comfortable.
oh, Gerald, are we boring you, Gerald?
Just getting comfortable.
I just have concerns about shaking that world, and we've not allowed any input, any discussion to make those changes.
To that point, Mr. Chair.
Contrast.
Ms. Good, I totally agree with you. I would respect the argument a lot more if I had 100 attorneys out here fighting with Mr. Allen. You know what? I understand how it was said earlier, you know, they're scared of the bar and this and that, but you know what? We have to sit up here as legislators and fight. And if we don't fight and we just say yes or no to whatever we say, we have to fight. And you know what? They might not like what we have to say, and they might not reelect us, but we're still fighting a fight. If an attorney is against the bar, well, come here, state your point, and you know what? That's what attorneys do. They fight all the time. They go out there and they state points all the time. They figure out what is, and you know what? If they find a loophole in something, they figure that out too. But they're not here to fight the fight. So you know what? I can't back something if they're not willing to back themselves.
Mr. Allen.
Mr. Chairman and members, I sometimes appreciate the legislating by anecdotes, you know, by who's been wronged the most, and we kind of weigh it that way. You know, but what it is there's a culture that has come about from the insulation of the bar, a culture which even the governor has railed against in judge selection, and you know, that has come across from the bar. Whether you think it might exist or not exist, but to quantify that is not as relevant as, wait a minute, what might cause this culture to take place? What causes this culture to take place is an illegal takings. And in illegal takings, all I want to do is to prove to you through sheer construction of our Constitution that this activity shouldn't go on the way it is. That's my argument, and that's why I don't want to have to bring in a whole bunch of people who say they're afraid of the bar, because I think the culture will improve, and I don't think it puts the bar in jeopardy to keep them in a constitutional box in which they were created.
Mr. Chairman, to that point.
Representative Goodell.
Whether it's a perceived tax, it's the Constitution, I still believe the people that are going to be impacted by this should have the opportunity to discuss. Maybe they would look at it differently. That maybe they would not make any changes. Maybe, but they should be provided an opportunity to get to the table and say, we appreciate your concerns. Let us see what we can do. We can't do, we don't want, whatever it be. And I just think that before we legislatively whoop things differently, people impacted should have the ability to meet and discuss what could be done differently or whatever. And I just have grave concerns when we drop bills and we've not talked with the impacted people. I understand the levy, but you've not provided any opportunity for the state bar to come and say, good point, let us see what we can do. And that's my largest concern.
And Mr. Allen, I don't know how to respond to that except for to say that I believe that the legislature has a fiduciary responsibility to organize government in a constitutional fashion. And that whether or not people are happy or unhappy with the organization, if it's constructed in a way that's not legal, that we correct that.
So let me ask, if this were to move out of committee, and I don't know that it is, I have no idea where anybody stands. I don't even know where Representative Goodell stands other than she's unhappy that she didn't have stakeholder meetings, but I don't know if she likes the idea or not. But if this were to go out of committee, would you be willing to commit to meet and confer and discuss?
And I would like to see them straighten this out themselves. But, you know, I don't think that that's where they're at. But maybe let's hear from
I'd love to see the discussion continue. I think it's interesting enough with other states that are doing it and some of that I'd love to see it continue. And
would you like to hold the bill then?
If we could, well, I'm happy to hold it and have the discussion this week and see at least if that's what you want to do. You're the sponsor. I'm not going to say yea or nay.
Well, why don't we give the guys who have been sitting here patiently wanting to have a little bit on the record. I would hate to then to hammer them around the head, then not give them an opportunity to at least come up and say, hey, wait a minute.
I don't think anybody's hammered yet. You guys feel beaten up? Rick, you feel beaten up yet? Yeah. Yeah. You weren't even awake, were you? Somebody just nudged you.
See, uncle at any time.
Yeah. Well, you're signed in. You're signed in to speak. So, okay. Well, let's take a little testimony, and you can decide if you want to hold it, move forward. It's up to you. John Phelps. State Bar of Arizona. We're going right to the meat of it, Representative Goodale.
The heart of it.
Right here.
Way to do
To
it.
the heart. Valentine's Day, yes, the heart of it.
Yes.
Mr. Chairman,
Nicely
members of the
played.
committee, good morning. My name is John Phelps, and I am the CEO and Executive Director of the State Bar of Arizona. And happy Valentine's Day. I know lawyers are a little hard to love, so I'm asking for some special dispensation this morning. Appreciate very much Representative Allen's opportunity that he's given us to really talk about the bar and why it is different. Before I do that, though, I did want to clarify a couple of issues that came up in your discussion, if I might, Mr. Chair.
Please. Yeah, you have 2.5 minutes to do so.
Okay, I can make that happen. The numbers of bars that are mandatory is a little bit flipped. There are about 30 bars in the country that are mandatory, and it's actually the minority that are voluntary. So, but as was mentioned, this is an issue that has really been floating around since the very beginning, since the very first mandatory bar in 1927, the North Dakota bar, and has been litigated in virtually every state and in the U.S. Supreme Court. And it's been held constitutional. Mandatory bars have been held to be constitutional by the U.S. Supreme Court and have been litigated not at our highest court, but the appellate division in Arizona, and found to be constitutional as well. I also wanted to point out that since 1933, as Representative Allen pointed out, the bar was established by the legislature, the State Bar Act of 1933, but it has been mandatory for that period of time. And that was really consistent with the trend in a lot of the western states. Right around the 1930s, many of the western states created mandatory bars, and Arizona was part of that trend. With respect to how many lawyers like, dislike, are unhappy with the bar, we do a membership survey every couple of years. The last one we did was in 2011. And we ask all kinds of questions, and then we have open-ended narrative parts of the survey that allow lawyers to say whatever the heck they want. And the last time we conducted it, 75% of the lawyers polled, and it was a statistically valid survey conducted by a third party, by Professor Merrill out of ASU, who does lots of polling and lots of surveys, found that 75% were satisfied and 25% were not satisfied. And as far as a mandatory kind of organization goes, the report said that was a pretty good number. I'm not surprised that we've got lawyers that don't like the bar, and I'll talk about that in just a minute. I did also want to clarify that although people might be afraid of the bar, and I've been told I'm a little bit scary, kind of a scary guy myself, the truth is the bar doesn't have the authority to disbar, suspend, or levy sanctions. All of those really are done by the court. The bar is really the investigation arm and the prosecution arm of the system. I also wanted to comment on Representative Goodale's discussion. One of my mentors that I greatly respected in my first career as an Army JAG officer used to say, Phelps, if you want it bad, you get it bad. And I think, there's certainly room for discussion here to explore whether or not the structure should be changed, whether we ought to look at some other issues that are valid issues and legitimate questions. But to rush through this and completely throw the baby out with the bathwater, we think is a bad idea. Now, why is the bar different than a trade association or a trade union? It's different because it is an integral part of the legal system. Lawyers are part of a profession, and they are officers of the court. They take an oath. And part of that oath, in Arizona anyway, says that each of us that are lawyers signs up to be part of the legal system and to advance and enhance the public welfare. And that's an obligation and commitment that every lawyer invests in when he or she takes that oath. And so the whole concept of the bar is that every lawyer needs to be a part of that. Now, whether they actively participate in promoting the public good and the public welfare as a member of the legislature or as a public attorney or doing pro bono work, all of the many different ways lawyers can do that, they are part of that effort, and they must be invested in that, at least under our oath. And the most important thing that I want to say, and then I'll sit down or I'll entertain questions certainly, is that the difference between a voluntary bar association and a mandatory bar association is, or mandatory bar, is the association is really much more like a trade association. It's there to advance what lawyers want. The state bar is not here in Arizona to advance what lawyers want. It is here to protect the public. We underwrite what should be the expectation of every citizen in Arizona, and that is when they go to see a lawyer, that lawyer is professional, they're competent, and they're ethical. And how do we do that? Well, we establish standards, we enforce those standards, and this is really important, and this is a big difference between a voluntary bar and a mandatory bar. We take the information and the knowledge and the work that we do on the regulatory side, and we parlay that directly into programs that develop and improve and remediate problems that lawyers have. A voluntary bar has no incentive to do that. Their only incentive is to do what the members of that association want to do. The mandatory bar, and everybody's invested in that, is there to not only regulate and deal with lawyers that fail to meet the standard, but to again, take that information and directly apply that. A great example is a couple of years ago we had lawyers having difficulty, a trend we saw on the regulatory side dealing with trust accounts. So what did the bar do? We immediately put into place programs to help lawyers with trust accounts, both on a remediation basis but also in a continuing legal education basis. Would trust accounts be the most popular CLE program for lawyers in a voluntary bar association? Probably not. But we've got a commitment and a requirement to do that, and I think that makes us different. And is a voluntary bar option, is that model reasonable and legitimate? Sure, other states have it. Is it the best to protect and underwrite what citizens should expect from lawyers? We don't think the voluntary model is, and we would ask that you oppose this bill, and I stand here in opposition.
Thank you. Just for the record, I gave you 7 minutes, so you could really put your whole heart into it.
Thank you, Mr. Chair.
You're welcome. But I'm expecting Rick isn't going to come up and just mimic what you said, right? You're a peach. Okay, Mr. Allen.
Thank you, Mr. Chairman. Mr. Phelps, let's move this activity. Let's say it's over in the executive. Police officers, they take an oath, very similar source, but they're, of course, on the executive side to uphold the Constitution. They have standard boards that police their activities, set down their policies, stuff, but they have no mandatory fee for being a police officer because they can't. we wouldn't allow it. Why should we allow it in the courts? What's constitutionally superior about the Bar Association compared to the police organizations?
Mr. Phelps.
Mr. Chair, Representative Allen, the difference between a sworn law enforcement officer and an attorney that takes an oath is, in fact, in the oath that we take. The oath that Arizona attorneys take is similar in as much as it requires us to uphold the Constitution of Arizona and the Constitution of the United States. But it goes further and says that we will adhere to a creed of professionalism. And within that creed of professionalism is an entire component that talks about our obligation not just to defend and uphold the constitutions of Arizona and the U.S., but to be part of the enhancement and the improvement of the rule of law in the state. And so there's an investment by everybody that has a privilege. It's not a right to be an attorney. It's a privilege to serve as an attorney. That makes it different. And if you allowed officers of the court, members of the bar, to opt out of it, then they certainly wouldn't be part of that. And I think the overall profession would lose.
Mr. Chairman, Mr. Allen. Mr. Phelps, I'd like you to point to the constitutional difference between the executive branch and the judiciary branch that allows you to force people to pay this dues. I don't see it. You created an ongoing fee, annual fee, that I don't think you have a constitutional right to. Can you point to where in the Constitution the courts are allowed to address a levy in that sense?
Well,
Phelps.
Mr. Chair, I apologize. I'm not prepared to address that specific issue, but I think I don't think that there's a requirement that any fee that's imposed, or license fee or otherwise, by the court is required to be specifically articulated in the Constitution of the state.
No, Mr. Chairman, but and Mr. Phelps, the activities of the bar are, as you say, for the furthering of the judiciary. Unlike paying for a license in general just to practice something, you're using these fees to further the judiciary, which means you're using them to supplement your activities as the court. And I don't see the legal ability to do that. It might be nice, but I don't see how you have the legal ability to have an ongoing levy against individuals who are involved in court activities. In the same way, the executive does not have the ability to tax police officers for the furtherment of police enforcement.
Mr. Phelps.
Mr. Chair, Representative Allen, much greater legal minds than I have reviewed the arguments about the constitutionality of the mandatory bar in Arizona and the United States, and have found that to be constitutional. And I don't have that case law in front of me, but I'm guessing that the issue of fees and mandatory membership were part of that consideration. And I would say that the bar is not just in support of the judiciary. Certainly the regulatory part of what we do is, but as I mentioned before, we have an obligation to the entire legal system. And a lot goes on within the mandatory bar that is focused on improving that. We have 28 different sections in different areas of the law that without the resources of the bar would not be able to do, certainly to the extent that they do, provide input to the legislature and to the executive branch on proposed changes and things that are designed to improve the law. So,
Mr. Chairman, and Mr. Allen, just to that point, I appreciate that, and I'm not saying that everything you do is evil, but when you go outside your fence outside of your authority to do something, it doesn't matter if it's a good thing or not. I mean, the courts deal with that every day. You know, people do things that are illegal for good reasons, and it doesn't make it right. So, but, Mr. Chairman,
Mr. Allen,
I think I'd like the bill held. I think we're going to go round and round and not. I will defer to the fact that perhaps I should have spent a little more time talking to people, but I do think the constitutional angle of this is correct, and perhaps this is not the correct venue, or at least at this time.
Okay, very good. And you wore him down. One speaker, you wore him one. I mean, come on, we haven't even gotten to the heavyweights yet. Just kidding. In respect, in deference, we will go ahead and hold the bill.